Good morning, everyone. It's time for us to get started. We want to say thank you for joining us this morning for our webinar, Putting the Puzzle Pieces Together, Complex Substantive Change. We have wonderful information to share with you today, but first, we do have one procedural item that we want to discuss with you. This presentation is property of the Middle States Commission on Higher Education, and we have for you this morning a typical lawyer disclaimer, so it's good that the lawyer is starting us off with this discussion. If you want to utilize our webinar materials in any way, please submit your request to president@msche.org. My office does review those requests, so I will have the opportunity to see it. And with that procedural item out of the way, we do want to get started with why you're really here and what you want to hear about, the substance of our webinar. So first, we'll give you another nice welcome and some introductions. On behalf of the Middle States Commission on Higher Education, we're excited to have you join us on this Friday morning. I'm Tracy Schneider, Senior Vice President for Legal Affairs and General Counsel for the Commission. Joining me today is Dr. Bassam Deeb, President of Trocaire College. I'm going to let Bassam introduce himself, but I do want to say what a pleasure it is to have Bassam join us today, as he has a very unique perspective and a wealth of information to share on this topic of complex substantive changes. Bassam?
Thank you, Tracy. Good morning, everyone. I am the president at Trocaire College, and I've been at Trocaire for about 12 years. Historically, I've been in higher education for about 36 years, mostly in the student affairs enrollment services area, and became president in 2012. I've been a peer reviewer with Middle States since about 2013, and obviously we've been involved in a number of attempts at complex substantive changes related to mergers and acquisitions. And so I'm thrilled to have the opportunity to be with you this morning and to share some thoughts on what you might want to consider moving forward.
Thanks, Bassam. We do want to begin today by talking about what we hope you gain from this conversation today. The Commission has hosted a number of webinars on complex substantive changes. Of late, we've been hosting probably webinars in both the fall and the spring, and those webinars have covered some in-depth substance about our process and the complex substantive change process specifically at the Commission. Today's webinar is a little bit different. We're not going to be covering as much procedural detail. We have that information available to you and to your institutions at any time, and your Vice President Liaison can absolutely share some additional information about process. But when Bassam was gracious to join us today for this webinar, we were able to take a slightly different approach. So what Bassam and I hope to share with you today is a discussion of the complex substantive change process from two different perspectives. Bassam's perspective, of course, is about engaging in this type of transaction as a college president. And the Commission's perspective, or probably more specifically my perspective, as the Senior Vice President for Legal Affairs and General Counsel who reviews these transactions on behalf of the Commission. And so I'll be taking the Commission's perspective. So starting us off in this process a little bit, I'm going to turn to Bassam to talk a little bit more about the institutional perspective and what he hopes you take away from this conversation from his perspective. Bassam?
Thanks, Tracy. Initially, as we talked about what this piece needs to be and how do we articulate valuable information and direct information for you as attendees, we reflected a little bit about what is happening in the landscape of higher education. And I think it is clear that the notion of institutions seeking collaborative efforts, irrespective of how we define collaborative, and we'll talk about that as the webinar progresses, requires a little bit of thoughtfulness at the institutional level to consider the ramifications of pursuing those pieces. So the reality of the complex substantive change from an institutional perspective actually goes beyond just what Middle States is expecting. And so we think, to begin with, if there are considerations by the institution to seek changes, we think that the first step is to have a confidential conversation with your VP liaison on the Middle States staff, and potentially some additional Middle States individuals like Tracy to talk about what it may entail, because obviously not only do you have to deal with middle states, you have other regulatory entities that you have to cover, and we'll talk about those in a minute. But the guidance for complex substantive change is really something that institutions often fail to look at. They just get focused on the collaboration, on the strategic alliance that they're pursuing, the conversations that happen, and then try to fill in with the requirements that really should have been part of the thought process initially before pursuing those options. Next.
Thanks, Bassam.
Yeah.
So the way that we are going to present the material today is by introducing a topic, and then Bassam and I are each going to speak to that topic from our different perspectives. And what Bassam started to share, and what we both recognize so often, is institutions are entering into transactions hoping from a strategic perspective, but sometimes it's also out of some level of necessity. So in doing so, the early planning stages are sometimes overlooked. And where we'd like to begin today is with the early planning stages and that importance of early planning. And Bassam's going to start us off.
So initially, from my perspective, in having been involved in a number of efforts since 2016 at a variety of levels of engagement regarding strategic alliance, strategic collaboration, mostly with higher education, but in our case, because we're a college that is primarily focused on healthcare, we've also had conversations of strategic alliances with health systems as well. The conversation has to begin internally, and it has to be at the right level internally. So the challenge in higher education, I think, that when we talk about a constituency-based organization, invariably, when we come to decisions, we bring a variety of groups into the discussion, whether it's the faculty, whether it's the staff, whether it's the students. The challenge in pursuing this type of perspective requires a little bit more of an insular approach, at least in the early stages of it, in order to work through the definitions and the comfort level. So how do you stage the discussion? Who is involved in the discussion, and what timeline do you need to follow? Are pieces of the puzzle that you need to put together based on understanding regulatory requirements for your institution, the state that you're in, obviously middle states as the accreditor, the U.S. Department of Education, and we'll talk a little more about all of those later, but essentially taking that, creating some type of a penciled timeline, to say the least. And then in the process, you want to talk about in the staging process, you want to talk about who do you bring into the mix and when. Obviously, first and foremost, it's you as the chief executive officer of the institution. Obviously, the board of trustees has to be involved. But I've seen scenarios, not just with our institution, but with some of my colleagues, where it's a select group of the board. It's not the full board, because you're still working through various ideas and various concepts. And obviously, the confidentiality piece, and you'll hear us repeat that multiple times, is really critical in this process. Part of, I think, sometimes what causes things to not work is a lack of agreement on defining what is the collaborative effort that you wish to pursue, or the strategic alliance you wish to pursue. Unfortunately, in higher education, we use labels, and it permeates. The definitions permeate these labels, and people take different perspectives on exactly what it means to them. And so it is essential, I think, from an institutional perspective, to really focus on not only what does it mean to have a strategic effort or a collaborative effort, but also what are we comfortable with and for how far are we willing to go in engaging in a collaborative effort with an institution. There's clearly a difference between two institutions coming together to share resources, whether it's purchases, or whether it's an IT structure that they want to build together. But it also is different if we're now talking about movement of people program development, those kinds of things. So these have a variety of impact on the institution, and it is essential to know that. And then what is the desired outcome? Why are you having this discussion? What do you hope to get? Because invariably, if you don't spend some time thinking through that, when you get involved in a conversation with another institution or another entity, sometimes the flow of the discussion takes you in a different direction from what you had originally thought. And so you need to be prepared to understand what is the limit? What are you comfortable with, and for how far are you comfortable with going? I can tell you from a personal perspective, we had a conversation with a couple of institutions a few years back, and all we wanted is to talk about collaboration. And it took several meetings, and before someone in the room said, well, we're talking about a merger here. We're not talking about, buying health insurance together for our employees. And that at that point in time, everybody was like, no, that's not what we signed up for. So I think that kind of concept of clarity internally first is essential. Tracy?
Sorry, I clicked it and it just didn't go.
Right, that's fine. So here are some definitions. Merger, consolidations, acquisitions, shared services, changes of control or ownership. These terms, not only do they have legal meanings, and in some cases, definitional meaning that is different from state to state, depending on where you are as an institution, but it also has a different perspective in the institution itself. So I'll use the word acquisition just to make the point. Are we talking about acquiring an entire institution? Are you looking at acquiring a portion of the institution? Does your state allow that to happen or not? Those are the kinds of things that you talk about internally to make sure that there is a comfort level around this. Because at the end of the day, once you start down the path of pursuing these transactions, there are a number of things that you have to take into consideration, whether it's legal, whether it's a business function, whether it's financial, whatever the case might be. But at the end of the day, the unspoken issue that oftentimes gets institutions in trouble is the emotional decision you have to make. There is an emotional decision here, whether in a merger you're acquiring or you're being acquired. And oftentimes that emotional decision has a different implication depending on the structure of your board and the type of board members that you have. If you have more of alums of the institutions, more community members of the institution, where the institution is located. So those things really should be looked at, not only from a legal, strictly legal definition, or what does the U.S. Department of Education says about changes of control or ownership, but really, what are we comfortable with doing? And to that extent, when we talk about the desired outcomes, what are we trying to get at? Because invariably, you need to think through some scenarios before you engage, and those scenarios can evolve as you engage with another organization. So are we going to share a president at some point because maybe there is a vacancy at the other institution, or a vacancy develops as a result of this discussion? Are we talking about leaving both institutions whole and creating more of an umbrella organization? And there are others who have spoken about those variations as potentially less emotionally charged than to try to actually blend two institutions together. Is there an issue about physically relocating a campus or relocating a substantial part of the campus? Or if not the campus, relocating where the leadership sits, which then sends a different symbol to the community. So those are some of the things that you really need to work through internally before you undertake this kind of an effort.
And Bassam's comments, especially on that last portion about definitions, understanding what the intended outcome is of the transaction is so critically important that we can see that from the commission's perspective at this stage. We recognize that institutions are at different stages in the process, but it is the substance of the intended outcome that helps the commission to align the institution's transaction, the intended outcomes, the substance of the transaction into the commission's definitions. And as Bassam accurately pointed out, there are different definitions for the legal context, for the state context, for the federal context, and for the accreditor's context. So the commission has a full set of definitions. And luckily, we do have a lot of information that we're able to provide to institutions about those definitions. And those come in the form of our substantive change guidelines. Again, here we're not talking about the procedural documents that identify how you go through a complex substantive change. But here we're really talking about the substance of the transaction and how that would be defined by the commission. And those, we understand and recognize that at different stages in the transaction, the substance of that, if you haven't fully agreed on the intended outcome, sometimes the substance of that transaction changes throughout. And so it really is important to start with that intended outcome so that we really understand the full context of the transaction and can be able to help you align it with our definitions. And we have found that many of our definitions, and we have drafted and defined each type of transaction in accordance with much of the same terminology that states and the federal government are using. Certainly our change in ownership definition is aligned with that of the United States Department of Education. But then the specifics of the transaction, I want to speak to a little bit as Bassam started to use some of that terminology. And I want to share a little bit about how the commission would define some of those different types of transactions. And we know sometimes the terminology can become confusing, and the commission's guidelines document is not the only place where you can find information. Certainly, you can speak to your vice president liaison. Sometimes I'm brought into those conversations fairly early on so that I can help to bring in those legal components and align those with our definitions. So, and sometimes just there's one little element of a transaction that can shift a definition from the commission's perspective. I am sharing with you just the most common types of transactions that we have seen at the commission. One of those is one that Bassam mentioned before, and that's an acquisition. And it may, certainly we have two types, whether or not the institution's being acquired or whether or not the institution is acquiring another institution. The critical component for the commission about an acquisition is it is the only transaction where two legal entities can remain separately accredited following the transaction. So that acquisition is a really critical, if that terminology is being used, that signals to the commission that there's going to be two separate legal entities remaining after the transaction. And either institution can be accredited by the commission or by another accreditor. We also frequently see mergers. A merger by the commission's definition is probably the one that most closely aligns with the Department of Education's and most state definitions. And that's where two institutions are coming together in common ownership, but only one institution, one legal entity will remain after the post-transaction. And there are different aspects of that are really critically important, especially to what Bassam was talking about when there is sort of an emotional component of that type of transaction, because one institution, in essence, will be closing. And that's very hard sometimes to embrace as part of the definition of merger. We also have a consolidation. Consolidations are similar to mergers, but usually a transaction that often includes multiple institutions coming together into that ownership structure. In some cases, and in some states, that doesn't have any separate legal significance, like a merger or an acquisition. And sometimes the term consolidation is used to either match the terminology of our state partners, or because that is Sometimes a more desirable term, perhaps from an emotional perspective, maybe from a political perspective, than say a merger would have. But perhaps my favorite category, maybe all lawyers' favorite categories, is our catch-all category. So this is the point at which, from the commission's perspective, I really want to highlight one thing. We're not trying to change your transaction. We are not trying to tell you what transaction is best for your institution or what your intended desired outcome is, as Bassam was talking about. We are just saying, here are the definitions. We're putting them out there for you. And we're saying, tell us about your transaction. Tell us about the substance of your transaction. And we will align it into one of these categories. And the commission does do that, regardless of what is checked off on the form. The commission will align it into our definitions for a reason. And that catch-all category can be really helpful because it is just any other category that may not fit into this other type of definition. And at the commission, we've seen a lot of different types of transactions, and we have seen many that fit into that catch-all category, which really can't be defined by one of the other terms, but is something that's certainly a permissible transaction, and we're happy to assist institutions as you're walking through that process. So the critical next step may be still connected to the planning phase, because really there's so much that happens at the planning phase. But what we'll talk about more specifically now is identifying the partners in the transaction. And Bassam, do you want to get us started from the institutional perspective, identifying and selecting partners?
Absolutely. If we can go to the next slide, that'd be great. Thank you. One of the challenges I think that institutions have that are contemplating some type of a collaborative effort. We'll continue to use that term, so we're not stuck on one definition, as you've just seen from the breakdown that was shared with you from Middle States. Is that it depends on the approach that your institution wants to take. There may be regulatory agencies and entities you have to go through, and it is an extensive list. And the intent here is not to cause you concern about the fact that you can't get through all of that, but it is important to be thinking about it up front, particularly when you're dealing with a critical decision like this, which invariably is involving your board of trustees. And my suspicion is that your board is made up of a group of individuals that are either professionals, are in the business sector. They may be familiar with mergers and acquisitions and those kinds of things from a business perspective, but don't quite understand how it plays out when it comes to a nonprofit organization, or even sometimes a not-for-profit institution coming together with a for-profit institution, or the other way around. But in the higher education space, there are things that are a little bit different. So if we can go to the next slide, I think is important to just talk a little bit about the various pieces. We chose to put this because, as you see, we're not talking about scenarios where we're still discussing, the missions of the two institutions, and if the institutions happen to have some legacy that needs to be considered in the process as well. We're jumping into the partners because these entities invariably have processes themselves, they have timelines themselves that you need to be considered. So whether you're public or private, obviously the sponsorship is important. So, and we've seen, unlike the perception that these things strictly happen in the private sector, we have seen public institutions involved in these kinds of transactions, although maybe the motivating factor or the person that's pushing the agenda for that may not always be at the presidential or board of trustees level, but it may be at a higher level, such as a governor or a state coordinating agency of some sort. State regulatory agencies require your engagement. I'll use New York State as an example to make the point. Not only do you have New York State Department of Education that you have to consider, but depending on the program mix that you have, You have the Office of the Professions that has to be involved. There may be others as well. The State Attorney General invariably, particularly when you're talking about not-for-profit institutions, are involved. The Bureau of Charities is involved because there are endowments that have to be decided on who's going to continue to hold the endowments. Will the new entity hold the endowments? Are going to be spun off into a foundation of some sort? And then you have to deal with the expressed wishes of those who donated the money. So there are engagements there, and those take time. Obviously, the U.S. Department of Education at the end of the process is involved, and they continue to provide some additional articulation as to what their expectations are, particularly when there is a change in ownership. You've got the program-specific accreditors. So not only do you have middle states as your accrediting entity, and especially if you're also talking to an institution that has a different institutional accreditor involved in the process, but then you have program accreditors who have to be involved, and invariably they have a process and an expectation and a timeline that you need to deal with. And then there's the whole financial piece, and oftentimes many of institutions have sufficient capacity on their board, financial advisors that can then give some perspective on how to finance this particular transaction or what issues you have to consider. But invariably, if you have outstanding debt in the form of bonds, and those bonds are held by multiple entities, then that essentially there's a whole process there that you have to engage in with the custodian of the bonds to make sure that the bondholders understand what's happening and what the potential impact might be on the transaction at the end of the day. Those are some of the things that we think you need to be considering in the process, particularly, again, as you consider what transaction you want to pursue. And I want to reiterate something that Tracy mentioned. When you fill out the form, after you have conversations internally, you talk to your VP liaison, there is always the potential that as you engage in the conversation with your partner institution, that things will change in the process. So either you may have clarity, but they may not have clarity. Or let's assume you both have clarity, but as you continue the vetting process and the engagement, you realize, no, this is not a merger, this is an acquisition, or this is something else. You have to keep that in mind. And that's why I think that constant communication back and forth is important to make sure that you don't go down a conversation so far that you realize that your documentation and the information that you're submitting to these regulatory agencies now have to be reshaped and resubmitted, which then takes even more time than you had anticipated it originally. Tracy?
That's an excellent point, Bassam, and you'll hear Bassam and I, share some of the same information, each from our own perspective, but that is really an excellent point about, the sharing of different information across groups. And you'll hear me talk about it. I will as we talk about the different aspects of the process and some of the tips that we want to provide to you. But that early and frequent communication is really helpful to cut down on some of those issues that Sam just talked about. And we'll talk about it when we talk about adapting and pivoting. But it's absolutely the case that you can pivot. There are different stages of the commission's process, and you can pivot throughout the process. But the commission will always look at the consistency of information that you share across these different regulators and the different partners with whom you have to share information or possibly receive approval. And you'll hear me talking now about the different partners that we see in the process. And the commission really does truly hope that our member institutions are seeing us as a partner in this complex substantive change process. You already heard me say once that we're not trying to change your transaction. We're not trying to dictate what your transaction can and cannot look like. In fact, the commission only has a few hard and fast non-negotiable rules about what you can't do. And most of those rules are fairly obvious. So you'll know them right from the start. You can't, and they do appear in our policies and procedures as well. You can't engage in an impermissible transfer of accreditation to an unaccredited, ineligible entity. That's one of our rules. We just can't transfer accreditation. That's the rule we call it. And that is one of the hard and fast rules. That doesn't rule out any of the transactions that we've talked about here today. You also have to maintain compliance with our standards for accreditation and requirements of affiliation before, during, and after the transaction. I also don't think that comes as a surprise to anybody. So we really do see this as a partnership. We want to guide and help provide you with information. We understand that sometimes maybe it's harder to see us as a partner in the process because we undertake an approval process as a member of the regulatory triad. And for those of you who aren't familiar, although I think most people are, but when we speak specifically of the regulatory triad, we're talking about the Commission, State Department of Education or the State Licensing Authority, as Bassam was talking about, and the United States Department of Education. We do have to approve your transaction, and there is a process for that approval, but we want your transaction to be successful. We want you to fulfill the vision you see for your institutions, for the intended outcome that we've talked about. And we are partners in that process to provide guidance and to share information across with the other members of the regulatory triad and across the triad in a way that helps you to navigate through the process. And that's where that consistency of information comes in. When we don't see consistent information being shared with the Commission, with the Department of Education, with your state regulatory bodies, that's when we have the most questions. And so really the alignment of that information and to see it as a partnership in that whole process really does help to make the transactional process and the whole complex substantive change process go more smoothly. The State Attorney General. So we have, we have talked about, and Bassam has talked about the role of the State Attorney General. And this is most specifically for institutions who are nonprofit or not-for-profit institutions. And you should be working with the State Attorney General's office early on to understand what the role is of that office in your state. It's not the same in every state. Some state attorney generals will review more transactions, some will review less. From the Commission's perspective, we do require the institution to gather information early on about the State Attorney General's office and whether their approval is required. If their approval is required, we accept the letter of approval. If their approval is not required, or if the institution is saying that the approval is not required, then we accept one of two things. We accept either a statutory reference that we can verify that says the State Attorney General's office does not need to approve that transaction, or we accept a letter directly from the State Attorney General's office saying they decline to review that transaction. And so if you can get that early on, as you can imagine, that's just another layer in the process that will also take a long time alongside other state regulators and the United States Department of Education. And it is really important, if you have that information, to gather that information as early as possible, because it is often an unexpected group that a lot of institutions don't think about having to contact early on. Certainly, if there are two states at issue too, there could be two state attorney generals that have to be part of the discussion as well. And I understand that in some cases that's not possible in every state, though perhaps becoming more possible in the near future for our friends in New York. Other accreditors. Bassam also talked about other accreditors, programmatic accreditors. There are also other institutional accreditors involved. So when we talked about the acquisition and how there could be two separately accredited entities remaining post-transaction, the entities can have separate institutional accreditation. And so it is really important that the other accrediting bodies, it's not just the Commission, that the institution makes sure that that information is shared and consistent information is shared with the other accrediting bodies as well. And from the Commission's perspective, this is really important. We're looking across to see if there's consistency of information. We do have different processes from the other accreditors. And we have often heard, why can't we just accept the application that I submitted to the other accreditor? Well, there's reasons for that. A number of those reasons is we have different standards. That's probably the most critical reason. If we have different standards, we have to make sure, and what we're doing is making sure your transaction aligns with each of our standards. So accepting somebody else's doesn't necessarily mean that we have the information we need to assure us that you are able to comply with our standards. But there's a lesser known issue that sometimes our institutions don't realize, is that the commission has to comply with antitrust obligations. So when we come to other accreditors or receive information about other accreditors, our decisions can't be based upon their decision alone. We have to make a separate and independent decision based on our own standards. And that has a number of implications for us. And then last, before we move on to our next topic, I do want to spend a minute talking about related entities. As institutions, you know, if you have a related entity, the commission does define related entities broadly, and we do have a policy. That definition is included right there in the policy, and examples of related entities can include a parent organization. So that's critical in this transactional process. If you didn't have a parent organization before, you may have one as part of this process. And they have to be engaged in the process. They have to provide us with information, and all of that information is laid out on the forms. And sometimes that having them, seeing the related entities, understanding who they are, having them as a partner early on can really make that process go smoothly. So the parent organization, a system is also a related entity. An individual owner can be a related entity. It does not have to be multiple people. It is one individual as well. Related entities don't include alumni associations, fundraising organizations, or specifically teaching hospitals. And of course, the vice president liaisons can provide you with more information. Sometimes you know who your current related entities are, but post-transaction, you may have new related entities. So that is a critical consideration in the process. Related entities also often provide funding and are a flow of resources to institutions, and those resources are often critical in the transactional complex substantive change process. So now that we've discussed planning, identifying partners, we recognize that these, and you've heard us say it a few times now, that these transactions are complicated, and I will use the next necessary joke. They are complex. So the transactions are happening at a time where you're also operating institutions of higher education. It's not the only thing going on. It is just one major thing going on in a group of many major things that are happening throughout the process. And there's a lot coming at you. And so really at this point, we want to talk about how you can be intentional about pursuing and maintaining clarity. Hassam?
Yes, thanks, Tracy. Before I make a couple of comments, I just want to make sure, you know, we've been at this for about 20, 30 minutes. And I think some folks might be looking at this saying, wow, this is overwhelming. I think the information is overwhelming. I think the processes themselves, if you plan, are manageable, because as Tracy just mentioned, you still have a job to do, right? Well, if you're the president of the institution, you're still running the institution. If you're the accreditation liaison, you're still dealing with those things. So everybody still has a day job. This becomes part of that process, and that's why planning is really important. And I share this because I've heard over the years that we've been involved in these conversations that sometimes institutions will say, well, we're going to try different things, and if it doesn't work, we'll see if we can do a merger or acquisition or whatever the case might be. Well, I will tell you that it can't be a byproduct of a number of other efforts that don't work, because it is complex. It does take time for it to happen. So to that extent, I think honesty and transparency between the board of trustees and the president are critical. There is nothing more detrimental to this effort if you have a president who has a particular perspective of what they want as the desired outcome and what the board expects and had thought articulated to the president. That level of clarity and openness and willingness to say those things that typically people don't want to say publicly, meaning inside the conversation between those two entities, are essential. Now, you notice I'm not talking about faculty, I'm not talking about staff, about students, because again, these are not transactions in the early stages where you can bring in constituents into the mix, because that thinking that concept has to really resolve itself up front. It has to be data supported. Oftentimes the data is, people will look at it and say, well, we just need the audited financial statements and that will tell us the story. The reality is audited financial statements are only a component of the process. You have to dig into your own information first, more than you normally do. Not just, what iPad's data, but what internal information that you have. Obviously, the institution that you're working with, that's part of it. You have to be willing to take risk. You have to be willing to say, we're going to go down this path, and we know that if along the way we might have to adjust, we're willing to adjust. And sometimes you also have to be willing to walk away after you've done quite a bit of work. So that's part of it. And I share this because sometimes higher education is accused of not being a sector that likes to take risk. The reality is that's not exactly true. But in this particular case, we're weighing into areas that are not traditional in the way we do business as institutions of higher education. Confidentiality, not only confidentiality internal between the board and the president, but sometimes you have to bring in key individuals into the mix. You may have to bring in your chief academic officer or your chief financial officer into the conversation. So you may be in a scenario where you, as a president, your entire senior leadership team is not involved. Only a couple of people are involved. In the same way for the board may be the executive committee of the board or the officers of the board, not the full board, at least in the early stages of this process. And then you need to, no matter what happens, no matter how preliminary you might be thinking about engaging another entity in a conversation, and even if you sign non-disclosure agreements, which Tracy could probably tell you more about the value of those, but the reality is there's always a potential breach of information, and you have to have something in place that you're willing to activate should there be a leak of some sort. And that could change as you progress through these transactions. Next. The confidentiality with key external approval entities is important. I will tell you, when in one of our transactions, we had conversations with our VP liaison. The other institution had conversations with their other VP liaison. And the VP liaison for that institution didn't realize that this was happening. And so all of a sudden now you've got conversations going on and people are confused. And so yeah, that is important, especially when you are talking to another partner. Just as much as you need to focus on your institution and what you control as far as how things are communicated and who's involved, the same has to be with your partner institution. There has to be an equal commitment to confidentiality. You got to build a coalition to get you through this. And the coalition is going to vary depending on your institution's legacy. I will tell you, in our case, we are a Catholic institution that is sponsored by the Sisters of Mercy, but the sponsorship is not a related entity, right? They don't approve budgets. They don't approve appointment of board of trustees or the president. But there may be religious institutions that are religiously affiliated where that entity does have involvement. So you have to know when to bring that group together to make sure that you move this process forward in a way that makes sense. You need to establish some clarity on the sequence of engagements, because eventually, as you get further down the road with the various entities that you're talking to. So for example, if you're pursuing, if you've moved along far enough that now you have to deal with a program accreditor of some sort, how do you communicate with a program accreditor if the dean of that program is not involved? So you have to figure out how you want to stage those things early on. The timeline is important. That you have to have a timeline that is based on all of the information that you have gathered, but also with a willingness to adjust the timeline either at a more aggressive pace or a less aggressive pace, depending on how the transaction, the interaction with your partner institution is, with your regulatory entities that are impacting your decision at the end of the day. So those are some of the things that, from an institutional perspective are important as you consider this kind of a substantial change in the way the institution is going to operate in the future. Let me talk a little bit about communication. I think oftentimes in higher education, when things don't go well, the first thing we look at is, were things communicated correctly? And sometimes even when there may be an issue, we just say, well, there was miscommunication. In this type of transaction, it is not just about communicating, it's about open and direct communication. You have to say what you mean. You have to articulate what you're thinking. This is not the time to put a spin on what you think is happening. You don't want to do that to a partner institution, so they're not clear about your intentions, and you don't want the partner institution to do that to you. You don't want your board to say, yeah, let's do a collaborative effort, and then halfway through the process say, well, I didn't realize that we're going to lose control as a board. You have to say those things that are typically not communicated directly and openly. There has to be an alignment on both institutions. So as much as I've been saying, you need to think about what you want as the desired outcome, you need to make sure that your partner institution has gone through a similar process, because this is where sometimes institutions go together thinking, oh, it's a merger and we're going to come all together and we're going to integrate. That's a good word a lot of institutions will use. We're integrating. And then you realize that it's not an integration. There will be a culture that will be a dominant culture, and there'll be a culture that is not dominant in a merger scenario. No matter what is said, no matter, even if you change the name of the institution and now the new institution has both names, there's still going to be a dominant culture in the process. If you read any publications on mergers and acquisitions in the private sector, that's often the case. And so in higher ed, the same thing happens. You don't want to be involved in submitting a complex substantive change, and then whether you're still debating exactly where you're going to go, because all it does is it causes some difficulties, it delays things, it becomes confusing, and oftentimes when there's confusion that sets in, the progress toward a desired timely outcome is lost. You do need to research the health and ability of the partners to get to the finish line. There is, again, I mentioned earlier, on the finance stuff, we're not just talking about audited financial statements, because with all due respect to the auditing process, sometimes the auditing process does miss things. I don't have to name any institution, but I will tell you, if you look at some of the institutions that closed in the last 5-6 years, and multiple higher ed publications have been tracking that, sometimes you will find those institutions to have had a clean audit. There may be management recommendations of some sort, but a clean audit, I put that in quote, when in reality, there's something more fundamental that is going on. So you have to do that. But you also have to be able to project not what the snapshot of the audit gives you, but how, based on what it's going to take, depending on what state you're in, depending on what reviews you have to undertake. Is this a 12-month process, an 18-month process, a 24-month process? Whatever that time frame is, do both institutions that are involved have the ability to get to the finish line? And you will see oftentimes institutions not being able to get to the finish line because they did not project appropriately how they're going to handle. And especially at some point in the transaction, things will become public. There are additional costs. Invariably, you have additional accountants involved, you have additional lawyers involved. When you talk to the state attorney general, you need to have a lawyer be with you. You can't speak to the state attorney general without an attorney who can interpret and help you navigate the expectations. So there are legal fees, there are things that are oftentimes considered as part of the cost to be able to get something done. So it is essential to make sure that the institutions have sufficient health in order to get through that process. Selecting internal personnel is really important because it's a combination of not just who is involved, right? So we don't just say, well, institutional research is going to be involved, so we need the institutional research director in this discussion. So it's not by virtue of the office that the person represents, because it is both a combination of the skill set that they need to bring, the information they need to supply in order for this to be a data-driven decision for you as an institution, but it also needs to be someone that has the ability to compartmentalize between what they do for their day job, thinking about this in a broad, critical, strategic way, but at the same time that you have confidence in their ability to maintain confidentiality. That is really essential. Legal counsel. Most institutions have either, well, at least in the private sector, many of them don't have internal legal counsel. They might have contracted service, but you may be large enough that you have in-house legal counsel. So if you don't have in-house legal counsel and you have to rely on a third-party engagement, you have to think about the relationship you have established with your attorneys who may be sufficient in the kind of work that you do today versus what else they can bring to the table for this particular transaction. And there are a number of law firms that have gotten more specialized in this area, but also not only your firm has to be involved, but the legal firm for the other institution has to be informed. So you have to really give that some thought in the process. Auditors and finance experts are essential in not only to look at the audited statements, but in some cases, you might have to do a forensic audit. That is not a typical piece that you do, but if there are complexities in the organizations that are coming together, multiple related entities, they might have some LLCs, they might have some 501c3s additional to who they are because they've done some different projects over the years. Again, that becomes more, so you have to get to a point where a more acute review has to take place. And auditors don't help you with financing, right? So then you have to have that process in place, particularly not only if you have outstanding debt that may be coming together or you're going to keep them separate, but maybe you also need to seek financial support to actually execute on the transaction. So that would be separate from what you might have outstanding for bonds for a residence hall, for example, or athletic field or whatever the case might be. Next. Depending on the capacity of your HR operation and the HR operation of the entity that you're working with, you might have to bring somebody else in. You may be in a scenario where one institution has collective bargaining agreements and another institution does not have collective bargaining agreements. And so maybe the institution that is driving the collaborative effort has or doesn't have collective bargaining and is not familiar with working in a collective bargaining environment, and their HR is not comfortable in that space. So you need to get that involved, somebody involved in that process. There may be a real estate issue or a facility experts. You might need to have architectural engineering firms to look at, if we're going to be combining, if we're merging and we're going to be integrating, administrative offices and academic programs and those kinds of things, is the facility sufficient? What is the deferred maintenance on ideal location for this new merged entity, those kinds of things. Strategic planning, organizational development experts may have to be involved. I would caution here a little bit in the sense that sometimes some of the entities that are out that do strategic planning may not be the right entities to actually help you get this project done. So you have to really vet through some of the individuals that do strategic planning for the sake of engaging an institution, a community to work on a strategic plan versus now you're talking about something that is more challenging and has multiple demands on it. So you just need to think about that. But the organizational development expert might become more of a necessity depending on the legacy, the developed culture of each of the institutions, and whether there are some things that have to be worked on as you begin to bring these entities together in whatever final decision you take, whether it's an acquisition or a merger or whatever the case might be. And then last but not least, other services, depending on who the agencies that you get, you have to have approval from. So again, depending on what state you're in, what other requirements, related entities, I think Tracy referred to them, you may have to bring some other people in. So all of this is not done cheaply. I cannot understate that. It's doable, but you just have to plan for it and make sure that you have thought through these various categories as you assemble those pieces together.
So I'll pick up here and I will say that all of those things that Bassam just mentioned, everything that we've talked about, all of those considerations, how you see each of those processes playing out, the plans you have specifically when you're talking about integration, when you're talking about bringing together two sets of faculty into one, all of those things require, and for the commission's perspective, requires transparency. And so we really want you to be able to demonstrate that clarity to us at that point in time, sometimes at each point throughout the transaction, really. So there are multiple stages in our process, and this is not a process-driven discussion today, but there are multiple stages in the process. We have early notifications, we have the preliminary review form, we have the complex substantive change. And I think institutions often feel, well, why? Why do we have to have each of those steps? It just feels like another step in the process. And the truth is, it's because if you can provide us with plans that you have, transparent plans that you have, regardless of what stage you're at, if you show us at each part of that process what your plans are, and you can demonstrate that with some level of transparency, even if it means we don't have clarity in this area yet. If it's an early notification or a preliminary review, we don't have clarity in this area yet. We're gonna be able to get that. We can also provide guidance at each of those stages. So the commission has seen a lot of these transactions go through, and we can help, and we'll talk about that in terms of confidentiality in just a minute, but we can help you, put you in touch with other institutions who have done this with their permission, of course. So you can help to be able to obtain that clarity. And certainly if the clarity is something about the commission's approval process, or even helping to facilitate the approval processes of our state partners or our federal partners, we can help in that process as well. And of course, unfortunately, that always brings up questions that people have about confidentiality. Bassam talked about it. He talked about non-disclosure agreements. I certainly can give lots of information about non-disclosure agreements, but I'll start here. Institutions often sign non-disclosure agreements, and I understand, I am a lawyer, so I understand why your lawyers want you to do that. I absolutely understand the value of those non-disclosure agreements. What we ask is that in those non-disclosure agreements, you have avenues to be able to disclose information to your regulators. If you're working under a non-disclosure agreement that does not let you even share information with your regulatory and approving agencies, you are going to be well behind the 8 ball in trying to move this transaction through. If you can't share information with us, if you can't share it with state regulatory authorities, if you can't share it with federal regulatory authorities, you are going to put yourself well behind in the process, and you won't have those years that Bassam's talking about that you need to be able to kind of sustain yourself through these transactions. And I think there's a lot of misunderstanding about confidentiality as it sits with the commission. So we are able to protect your confidentiality. If you tell us, if you do all the things that Bassam talked about, here are our plans, here's who we can share it with, here's the core group that's talking about it. And that includes if at a certain point in time, there are multiple key contacts that the commission maintains. If it is just the president who needs to be communicating about a transaction at a particular point in time, especially the early notification stage, we honor that process. You just have to tell us that that's your intended result and that we can apply protections that we have into place. It's when we don't know it, as Bassam was talking about, that's what creates confusion, whether it's through vice president liaisons who don't know about their institution, who's engaging with a different institution, and we do know about it. That's where it can get potentially complicated if we're not able to help you navigate those discussions about confidentiality. We can protect your confidentiality. And let me make this very clear. We do not make your transaction public. The only two times the nature of your transaction becomes public is when you make it public or when the commission approves it in its action. And that's when we will identify with more detail what that transaction looks like. Otherwise, it's not the commission making it public, and we put protections in place for confidentiality. What confidentiality doesn't include, and sometimes we've heard institutions say, well, don't share this with the other staff or the other vice president liaisons. That's not how confidentiality works at the commission. So the commission staff all have a reason to know it. We don't make announcements throughout the whole organization, but we do share the information with critical key staff who can help guide you through the process. And so we do that. We don't share it external. But we do share it internally, and that's to assist the institutions. That's to help you navigate through the process. We certainly don't share information with other institutions unless you give a waiver of permission to do that. And a lot of times we'll ask when two institutions are engaging a complex substantive change, and both are commission accredited institutions, we will ask for you to waive our policy that gives you confidentiality and allows and requires the commission not to share information with the other institution. We ask you to waive that. And we do that again for the purposes of bringing everyone to the table, for the purposes of that clarity that Bassam was talking about. Certainly, you don't want another institution to be hearing about your clarity once you've waived those confidentiality provisions and we're all sitting at the table. You all as institutions should be able to share that in advance. And the commission's just there to help facilitate through that approval process. So we understand confidentiality can be really important in this stage, and we really do want to share that we have those protections in place to help protect that confidentiality. And of course, all of the information we have will help us to help you navigate through the complex substantive change process. If we have that transparency, we can help you gain the clarity, and then we can help you navigate through the process as well. And I don't want to spend a lot of time on this slide because, again, it is very procedural, but it does go to what Bassam was talking about the amount of time. And this is just through the commission's complex substantive change process. But what I do want to point out here is that the commission's approval is often, not with every state, but it certainly is with the United States Department of Education, required first. So the other members of the regulatory triad, and again, not every state, there are state components that can happen beforehand, but certainly with the Department of Education requires that the commission approve the entirety of the transaction. So, and I think probably when we get to the Q&A portion, we'll talk a little bit more about the Department of Ed's change in ownership guidelines. But when we're looking at those, you can't start that process until you have the commission's approval. So these timelines are really important because they are in addition to the timelines that are often required for other approvals. And I know this can be so daunting, but this proper planning, the ability to be able to adapt and pivot, which we'll talk about in just a second, is really critical. In the legal field and business transactions, they talk about how long a runway you have. And so it is really important to be able to have that runway, and to be able to adapt, to be able to share the information, and to be able to see what that timing takes. And the reason I shared that with you first is because this slide that I've put up on the screen for you actually identifies why the commission says it can take up to 1 year. Remember, that's just for our approval process. The up to 1 year is just for the commission to be able to engage in the entirety of that complex substantive change process. We certainly, if you do some advanced planning, we can engage earlier in the early notification stages. And so it can take longer by choice, by good planning, and by design, rather than trying to move it through quickly. We often have institutions ask, and usually that's in an unfortunate situation where we are engaging in more of a necessity transaction and less of a strategic transaction. If those approvals can come as quickly as 3 months? And the answer to that is no. It's simply not enough time for us to review a transaction. And usually in those situations, we don't have the transparent information that we hope to get throughout the transaction. So it does make the process a little bit more complex. So if we're doing some of these things we're talking about today, it really does make this process run more smoothly, and this timeline and the timelines that Bassam talked about not seem quite as daunting. So we know that timeline can be a bit much, but we share that because we do know it gives you sufficient time to be able to adapt and pivot. And I know Bassam has already been talking about a lot of that already today, but he has well aware of adapting and pivoting. And so I will turn it back over to him.
Thanks, Tracy. I think invariably our best plans, sometimes something happens and we have to make adjustments, right? You might have a scenario where the core group on your board of trustees, there's a change in leadership. Your board chair, who might have been heavily involved in this, steps off. The vice chair comes in and says, you know, I like the idea, but I don't know that I want to go this far. Where you're already in the process, you've already engaged a partner, you've already engaged regulatory entities, you know, middle states, those kinds of things. So, you know, there are hurdles. So I'm going to do this kind of reverse to how it's written. There are hurdles that you're going to come across. Your partner institution might have situations where, you know, the president decides to leave, or they had a vacancy. They were hoping to bring a president in to help them work through this transaction, and something happens. So there are things that are going to occur that you have to be aware of. And last but not least, on the hurdles part, to Tracy's point earlier, you know, you can work with middle states, and let's say it takes a year. You can start your processes with these other regulatory agencies as well. But in some cases, in some states, they're still adjusting to dealing with these types of requests, and they may not have processes in place that are well laid out. And so you may be navigating through challenges in your own state regulatory environment that is itself trying to adapt to the demand that is coming from these transactions. And I appreciate the comment about necessity transaction versus a strategic transaction. I think that's the point that I was making earlier, which is you can't have it be the last thing that you do when you're trying to ensure that your institution is sustainable for the long run. You'd have to build in some interim solutions. Do we, you know, are we going to, CFO leaves? Are we going to bring in a CFO? Are we going to go to the registry and bring somebody interim? Or are we going to use the CFO from the partner organization? And then how does that person now have accountability and responsibility to do different organizations? So those are some things that could happen along the way. The fiduciary responsibility piece, I mean, oftentimes we talk about boards of trustees as having a fiduciary responsibility, but presidents have fiduciary responsibilities, CFOs have fiduciary responsibilities to ensure that not only is the institution viable, irrespective of whether the transaction is taking place or not, but that it is also viable throughout this process that then allows for the transaction to be completed at the end of the day. And so to me, from what we've seen, those are things that constantly have to be in play. Last but not least, and I think an essential element, just like Tracy talked about in the NDA, you can have an NDA, but if you begin to restrict regulatory agencies from learning about what you're thinking and doing, it becomes a problem. I think sometimes not having in the transaction a conversation internally, but also with the partner institution, that there may be a point where you both need to walk away, just because after whatever effort and energy has been expended and resources, it just no longer makes any sense for this to continue. And you have to be able to and be willing to do that without seeing it as a negative. It's not easy, believe me. I can tell you from a personal experience or two that it does cause you to rethink why you engaged in the first place, why you did what you did. But the reality of it, you have to be able to walk away if that's how you can preserve the ability of your institution to be sustainable in the long run. Tracy?
So from the commission's perspective at this stage, are many of the things that ways that we can help you to adapt and pivot are ways that we've already talked about, which is understanding and receiving notifications of changes and updates. We've said throughout, these transactions change, especially if you give us early notification. We often know that they change throughout the process. We give guidance at each stage in the process in order to help you adapt. One other thing that's really critical that we have been doing, and quite honestly, that we've learned throughout the process, is to be able to sometimes guide you through two separate substantive changes at the same time. So you may be engaging in a particular transaction. However, based on the circumstances of your institution, it may also be that if this transaction doesn't work out, there isn't much of another alternative. And unfortunately, sometimes that means it's engage in the transaction or closure. And so while it is very difficult to be able to navigate your way through two processes simultaneously, we often will guide you through that process in order to help protect students. And the good news is we all know that everyone's interest at the table is protecting and helping students. That's what you do it for. And that's what our role is. It's our primary concern at the forefront. So we can help you to navigate different pivots, and we can help you to navigate those pivots fairly quickly. I understand that, we talk about whole timelines, but we can still talk about what happens and help you to plan for what happens if that changes. It's why we often ask for teach out agreements. And every institution goes, why do we need to do a teach out agreement? We're not going to close. But we do need you to plan for what might happen if your transaction doesn't work out. So the changes, the updates, understanding what's going on at your institutions is really critical to be able to navigate that process with integrity and in order to protect students. We also know that sometimes there's some political movement one way or the other towards these types of transactions. And so when, the media, when different aspects of politics and different political groups get involved and learn about some of these transactions, they can put some pressure on, sometimes to facilitate a transaction, sometimes to prevent a transaction. So hopefully, if you see us as your partner and we share that information early on, we can help you to pivot your way through those political inquiries that may come through. And that's also where we can help navigate with some of the other members of the regulatory triad as well. And our final topic before we get everyone ready for questions and answers, and I am thrilled because I just saw one question pop up for us. So we do have other questions we can talk to each other about because we've seen enough questions throughout. But I do see one come up, so we'll get ready for that question. But before we do that, we just want to talk for a minute about some reflections and some, final thoughts on strategies for success. And as we've done before, Bassam will start us off.
Thanks, Tracy. If you don't mind, Tracy, I think I would like to answer the question about egos because it kind of fits in the perspective of
Please do.
institution.
Please do.
Because I think it's a great question. I think I've soft pedaled this up to this point when I keep talking about openness and directness and say things that are not typically said, but that is exactly what I'm getting at. These transactions, if they are to happen in an honest, transparent, open way that really positively impact not only the institution you represent, but even the partner institution, the egos have to be checked at the door. And that is not an easy thing to do because, again, I referenced something earlier around emotional decisions. This is where, I have seen not only in conversations I've been involved with directly, but I've seen with other colleagues of mine and some of the other institutions that have been out in public around these scenarios where someone says, I don't want this, and this is why I don't want it. And it's about, I don't want it, not what is in the best interest of the student that we're trying to move forward with, or in the best interest of the institution. You have to, if you're going to engage in something of this magnitude, there has to be egos taken away from the process in order for this to be open, honest, because eventually, as you begin to build your coalition, if you allow egos to come into play, it becomes critical. And so, I had thought about doing this, my reflections from two different perspectives. From my personal standpoint, I think you think about, why do you do this? Why are you doing this? It's not fashion, right? I mean, we're not involved in, somebody else is doing it, let me do it. No, there is something underlying the reason why you pursue such a complex process, because it is complex. And so you have to be honest with yourself, and the individuals who are involved have to be honest with themselves about this. And then you need to also weigh the pros and cons. If it works, what does that mean? And is this one and done? Or if it doesn't work, do I try again? And we know, if you read the literature, that there have been institutions that have done multiples of these, and there are some institutions that try to do multiple of these and it didn't work. So it is challenging, but you have to give that some thought up front. From a general perspective, I think it is important to stay current in the field and really read every story, every nuanced situation that goes on in the nation, because even though it may not be relevant to you and your institution and your regulatory entities that you're dealing with, it potentially could pop up as a scenario. And again, as I mentioned earlier, and I think Tracy confirmed, that we still have situations where these regulatory bodies themselves are changing rules and updating rules. And so it is essential that you stay current. I don't have to tell you, inside Higher Ed Drive, the Chronicle, they all tell stories about what's going on, what institutions have been successful at, what institutions have not been successful at. And you need to go beyond the headlines. Sometimes you need to, if you hear of an institution that was unsuccessful, you might need to try to see what the local media where the institution is located is saying, to pick up the rest of the story of what actually happened, so that you can be better armed and more informed in the process. You need to look at publications outside of higher ed. The Wall Street Journal, New York Times, Bloomberg have been running quite a bit of stories related to higher education, because I think the sector as a whole is under some scrutiny, right? Maybe a lot of scrutiny, depending on how you perceive what's happening. in the landscape. But the reality of it is that this is going on fairly regularly. And then again, you got to keep track of your regulatory agencies as they make changes. I want to share with you just a quick story that this happened to me in the last 48 hours as we were coming into this webinar. I was at an event locally, and just to give you a context, Trocaire College is in Buffalo, New York. It's Western New York. There are 20 institutions of higher education, public and private, large state university, community colleges. The demographic breakdown is about 1 million plus in the region. So we're congested when it comes to higher education, and that's not taking into consideration institutions that are coming into the area and recruiting students away from the area. But 48 hours ago, I was at an event in the community, and somebody says to me, out of the blue, once they knew who I was and what organization I represented, said to me, you know, there's 11 private institutions in this town. I said, what are we going to do with all of them? We really don't need all of them. Unsolicited. It wasn't the topic. That wasn't, it was just, I just met this person and we're just trying to get to know each other. So I think we as a sector are causing conversations to take place. You know, in other webinars, you probably are talking about you know, value proposition of a college education, those kinds of things. But in general, I think we are under scrutiny as a sector. And in the process, people begin to say, do we need that many? And particularly in the regions, and unfortunately, Middle States represents that geographic region of states that are not growing demographically. And so, and we have a history of a lot of institutions, public and private. And so as a result of that, I think we're going to see more and more, not only institutions engaging in this kind of an approach, but also pressure coming from our communities to say, what can you do together? Because we can't support all of you. Because at the end of the day, we rely on our communities to be supportive in fundraising and scholarship and opening doors for our graduates and our students and those kinds of things. So I just wanted to put that on the from an institutional perspective at this point. Tracy.
Well, it's certainly an interesting conversation to be able to navigate from that discussion, Bassam. I do just want to, by way of our reflection, I want to pick up on one thing that Bassam said towards the end before his story about his reflection. That's about changing processes, adapting processes. So the commission has seen enough complex substantive changes, different types of transactions, that we are also looking at where we need to change policies and procedures in our processes in order to align, in order to best support institutions, in order to help navigate all of the different types of transactions. So please know that we do that alongside, we adapt alongside of all of you as institutions as these things are coming to fruition and we're learning things in the process. I know that states are also doing that, so we don't have a lot of time to talk about it, and I want to make sure we address the few questions that we've had come in. But I know that there are state efforts in New York to be able to allow for a broader range of transactions. And we certainly all know that the Department of Education has changed their change in ownership process. That process is taking a substantial amount of time, that two-step process. And because it comes after the commission's process, we've had to adapt some of our policies and procedures to be able to help you all navigate those timelines. And we continue to do that and look at that. So that's been our sort of reflection in the process, and everything else that I would share with you has I've sort of intertwined throughout our discussion. So why not, with that, we go into the question portion, and we've seen a few come in. But if you have questions, please use the Q&A. And Bassam already answered one of those questions, but I think one of the other things that Bassam talked about early on is this idea, and we have a question that's come in about that, this idea of acquiring a particular program or a set of programs of another institution. And we have seen that sometimes. You see media reports, And so I think there's been some questions about, at least from the commission's perspective, but I'll let Bassam talk about this issue from his perspective as well, about what it would look like, and how institutions might be considering acquiring a complement of programs. And then I can talk about what that might look like from the commission's perspective. So Bassam, you want to start that off?
Sure. So there are a couple of things that to keep in mind. The question is really related to acquiring a program in which the institution already has approval to or authorized to offer the program. So I would say that it's going to depend on your state regulatory agency as to how far you can go with that. So in the case, and I'll just to make the point, in the case that you already offer an education master's degree or a baccalaureate degree in sociology, and you're acquiring an institution that is closing, and therefore you're only acquiring the education program or the sociology degree, those are likely to be driven by your state regulatory entity saying, essentially allowing it. And you normally would do that through that teach out process, particularly if you can get the institution to agree to have you be the preferred teach out institution for that particular program. I think that's a way to do that. I have also seen in a couple of instances, not in middle states, but in other institutional accredited regions, where an institution has sufficient academic support to house a particular program through a teach out process that gets approved by their state agency. And then in the process, while they're teaching out, they are submitting to their state to give them authority to offer that degree. So I've seen both of those scenarios play out, but I do believe that it is critical that your state regulatory agency weighs in on this, because it will vary depending on the state that you're in, and whether the institution is closing or whether you're even contemplating the acquisition before the institution announces that it's closing. So those may be some things that you have to also be taking into consideration. Tracy?
Thanks, Bassam. I'll just get to say, because this is my favorite time that I get to respond, my favorite answer that I get to give, because I'm a lawyer. And so the answer is, for the commission, it depends. It depends on whether or not something's going to be just a substantive change, or whether or not something's going to be a complex substantive change. And I will say here that that's the commission's determination. So there are regulatory requirements for what constitutes a substantive change. And then there are commission definitions and determinations for what makes substantive changes complex. And there's a variety of things that we consider: the need for specialized expertise. There's also the need for multiple substantive changes happening at the same time. To this specific issue, one of the things that we would look most closely at is whether or not an individual program was the only program offered by an institution. And then in reality, are you acquiring the institution, or are you acquiring the program? So there are those considerations. There's also considerations of how many programs and a whole complement of programs that might be coming together that you're acquiring or that are being acquired. And so all of those things are determinations about whether or not the substantive change is complex. And I know there's some other questions we have of a similar nature about whether or not a specific thing is a substantive change. And one of those that I'll look to is the types of partnerships with non-academic entities. Well, if there is a change of control, and that's what we've been talking about here, change of legal status, control, change in ownership, then it is absolutely a complex substantive change. They always are. However, there are other substantive changes that are not necessarily complex, but you could have a partnership that's, say, a written arrangement with a non-academic entity that's providing some kind of service to your institution, and that could also constitute a substantive change. So for those questions that are on here about the substantive change process and whether something's a specific substantive change, please always direct your questions to your Vice President Liaison if we haven't answered and we can't answer specifically here today, to your Vice President Liaison, or please substantivechange@mscag.org, and we can always help to answer some of those more specific questions for you. So I really do appreciate all of the questions that you have and a few that have come in about that. And we want to make sure we answer those questions. If you think of other questions that you might have for Bassam and myself, we're always happy to answer questions outside of this. And again, substantivechange@mscag.org, Vice President Liaison, or you can also direct questions to president@mscag.org, and we'll make sure that we can get your questions answered for you. And so as we conclude our presentation today, I do want to remind everyone that we do have resources available on the website for you. We have a policy section of the website. We have an entire substantive change section of the website. And of course, our standards for accreditation and requirements of affiliation, both 13th and 14th editions are up there. To keep up with the latest MSCHE news and updates, be sure to visit us on Twitter, LinkedIn, and subscribe to our YouTube channel because it does have webinar recordings and helpful explanatory videos. And we also have our annual conference coming up between December 11th and 13th, 2024, and we'll be at the Philadelphia downtown Marriott. And we're really excited for those days for the sessions that we have. And the student poster session is going to be opening on August 1st, and that's always really popular. So please check back on our website, and we'll be sharing that information with you as well. And I really want to conclude by thanking you, thanking everybody, but in particular, thanking Bassam for his time today, for joining us. It was a really wonderful discussion, and we certainly appreciate it, Bassam. And I want to thank you all for joining us today. We hope you enjoyed our webinar.
Thank you.
Thanks, everyone. Bye-bye.